Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show. Hello and welcome to the July 2015 episode of HR ListenIn. My name is Holmes, employment lawyer at Taylor Vinters' London office and presenter of HR ListenIn. We're now well into the holiday season, and it's no surprise that the issue of holiday pay and working time remains one of the most important talking points for employment lawyers and HR practitioners. This is the focus of this month's podcast, and I'm joined once again by my fellow employment team member, Scott Glacken. Welcome back, Scott. It's been a few months since we last presented together.
Thanks, Dom. It's good to be back. Hi, everyone.
Now, this month, we're going to be doing things slightly differently.
Yes, that's right, Dom. I know you've spent a lot of time recently advising clients and presenting seminars on these issues. So this time we're going to turn the tables a little bit, and I'll be asking questions and you'll be doing most of the talking. Our working time legislation has an increasingly unwelcome reputation for causing a lot of headaches and head scratching within the HR community. There's a lot of complexity and uncertainty, particularly in the context of the modern workplace where employers are more flexible than ever in terms of whether employees perform their work and how they're incentivised.
Yeah, I think that's right. Unfortunately, Scott, I think it's becoming more complex. Recent court decisions have created quite an uncertain framework, and there are some undeniably real areas of risk for employers in managing their workforce. But I also think we can cut through a lot of that just by going back to basics. The underlying concepts are simple enough to explain, and hopefully we can achieve that today, provide listeners with a solid foundation from which to consider their HR strategy and mitigate those risks.
Good stuff. So what are we going to look at today specifically?
Well, two things. First, holiday pay. We looked at this topic back in January in our very first podcast, which is still available on the Taylor Vinters website for those who'd like to listen to it now. There have since been a few more developments, so we're going to look briefly at those and also discuss more generally why the law's in a tangle and what employers can do to ensure they're compliant.
Sounds good. And the second area?
Second area is working time. When is someone deemed to be working and when are they resting? We'll discuss why it's important. Again, I'll give an update on some recent legal developments.
Okay, let's get started with holiday pay then. Where's the best place to begin, Dom?
Well, the basic rule is very simple. A worker is entitled to a week's normal pay for a week's leave.
Okay, I'm sure there's more to it than that, though.
Well, that's the starting point. A week's normal pay for a week's leave, and it's really important to keep that principle in mind at all times. But you are absolutely right.
So I guess the first question really is, what is normal pay?
Well, that is a very good question, one which we have all been grappling with for some time. Normal pay includes payments that are either intrinsically linked to the performance of employment duties or which relate to the worker's personal or professional status.
That sounds a bit woolly, Dom.
Well, yes, it is, in the sense that we don't have a definitive, exhaustive list of what types of payment count towards normal pay. This is what the courts have been working out on a piecemeal basis over the last few years.
Maybe you could give some examples.
Okay, well, basic salary will obviously always be normal pay. Other specific regular monthly payments, such as car allowances, those are probably included. They will generally relate to an individual's status or be intrinsically linked to the performance of their duties. Normal also means that the payment must have existed over a period of time, so there must be a degree of regularity or consistency in the payment.
And I guess there are some things that we know are not normal paid.
Yes, well, absolutely. Or anything which the worker does not receive regularly or which is not related to the performance of their duties or their status. So that would include, for example, occasional or ancillary costs, expenses claims, things like that would not be normal pay. And similarly, one-off incentive payments, perhaps some kind of retention bonus or a one-off Christmas bonus, that's not a normal payment. It's not a payment that's existed over a period of time such that it could be considered normal.
So there's obviously lots of scope for grey areas in between then, Dom?
Yes, Scott, which is why we don't have an exhaustive list, or at least not yet. The key areas of focus recently have been commission payments and overtime payments. These are particularly problematic because they often form a significant component of an individual's remuneration. And if we go back to the real underlying purpose of working time legislation, it's to protect health and safety, the health and safety of workers, by ensuring that they have enough rest and relaxation away from the stresses and rigours of work. So workers who are going to lose out on commission or overtime pay because they're on holiday are naturally going to be discouraged from taking time off, and this is where the law steps in.
So the idea is that workers shouldn't be disadvantaged by taking holiday. They should get the same pay they'd otherwise receive if they'd been at work.
Exactly. So it goes back to that very basic principle we mentioned at the outset. They must be paid a week's normal pay for a week's leave. It's now fairly settled that commission payments must be factored into holiday pay. Similarly, with overtime payments, if it is normal pay, it must be factored in.
So that gives rise to another question. What are the different types of overtime?
Well, yes, certainly. There are various types of overtime, Scott, and currently the cases identify three categories. So first, we've got guaranteed overtime. That's where the worker must be paid for overtime even if they're not required to work it. That is normal pay because it's paid regularly and it must be included. Secondly, there's non-guaranteed overtime. That is overtime which the employer is not obliged to provide, but the worker must work it if asked. Again, generally that must be included as part of holiday pay. And third, we have voluntary overtime. That's sort of overtime which is optional on both sides. The employer is not obliged to provide it. Worker can turn it down if he or she does not fancy working it. And this has been subject of a recent case in Northern Ireland, so not strictly binding in England, Scotland and Wales, but likely to be followed in my view. With voluntary overtime, you need to look at what happens in practice. Yes, it is optional, but if in reality it is regularly accepted and regularly worked, it may be sufficiently normal to count as normal pay.
So how do you go about calculating holiday pay, particularly if someone's pay packet varies from month to month?
So that's a good question, Scott. Effectively, you need to take an appropriate reference period. So 12 weeks is generally seen as a good starting point, a good barometer. You look at the average weekly pay for the previous 12 weeks leading up to that holiday period, including commission, overtime, etc. where appropriate, and you pay that average amount.
And will it always be 12 weeks?
Well, we can't say for certain. I think one area where there is very little guidance at the moment is something like annual bonuses. These could well amount to normal pay if they are received each year, and they can be very significant in some sectors, particularly the finance and banking sector. A 12-week reference period in those type of situations raises the spectre of everyone taking holiday just after a bonus is paid to maximise their holiday pay. So in those cases, I could see the justification for a different reference period, perhaps even a 52-week period.
So one area we've not touched on yet, Dom, which I do think makes things more difficult in practice, is the different categories of holiday.
Yes, Scott, this is where things do become a bit tricky. Now, annual leave entitlement in the UK comes from three separate sources. For full-time workers, there is a minimum 4 weeks entitlement under the EU Working Time Directive. Typically, we call this Euro holiday. There's an additional 1.6 weeks minimum specific to UK workers under the UK Working Time Regulations. So that's the bare minimum, 5.6 weeks. And often, the employer will give workers more than that. And this additional holiday is governed by the employment contract, which is the third source. If I can put it this way, if you, say for example, you take an empty wine glass and a waiter comes along, partially fills it with wine, so that represents your 4 weeks Euro holiday. Another waiter comes along, tops it up a bit, there's your 1.6 weeks under the working time regs in the UK. And then a third waiter fills the glass right to the top, and that's your additional holiday under the employment contract. You take a sip of that wine, but it's all mixed in together, and the same really applies to holidays. I suspect that in most cases, no thought is given to whether a particular day's holiday counts as part of your Euro entitlement, your UK working time entitlement, or your contractual entitlement. And different rules apply depending on the source of the holiday entitlement. Most of the rules we've been discussing apply only to Euro holiday, the minimum 4 weeks. Some of them may or may not apply to the additional 1.6 weeks, there's still some dispute about that. And for contractual holiday, the contract is king. So there is a real disparity in how they're treated.
So the question that our listeners are going to want to know the answer to is, what should they do?
Well, I think, Scott, it ultimately depends on First, the composition of your workforce, and secondly, the attitude to risk. Some employers may choose to ignore these developments and keep paying basic salary only as holiday pay. For those who have a significant number of employees on commission or overtime arrangements, I do now recommend carrying out some sort of audit of how holiday pay is calculated. The law has limited claims for backdated holiday pay to 2 years in most cases, but there is potential future liability to consider as well, and we can certainly help with those kinds of exercises.
So what about using the employment contract to reduce uncertainty?
Yes, the employment contract is always a useful tool for employers. You could clarify in the contract, for example, that European holiday is deemed to be taken first, then your UK minimum, then your contractual holiday. So at least you know where you stand, you know which part of the wine you're drinking at any particular moment. It could also say, for example, that for contractual holiday, the employer pays basic salary only. And on that last point, there's obviously an administrative burden of distinguishing between various categories of holiday and treating them differently. Sometimes an easier and simpler approach would be to calculate all holiday pay in the same way, regardless of whether it's European holiday or contractual holiday or whatever. And provided the employer is happy to bear some additional costs, because they may be paying slightly over the odds for contractual holiday, then sometimes that is worth paying that price.
So Dom, let's move on to talk about our second topic, working time. And let's start with the basics.
Again, Scott, there's a very simple concept which I think has become slightly complicated in recent years. As I mentioned earlier, working time legislation is aimed at protecting health and safety by ensuring that workers get adequate time away from work. And for this purpose, the legislation makes a very clear distinction between working time and rest periods. Any time which is not working time is counted as rest. And the law places every waking and sleeping moment of our lives into one of these two categories, which is obviously nice to know.
So why is the distinction important?
Well, there are a number of statutory minimum safeguards in place, including, for example, maximum working time of 48 hours per week. So unless a worker has opted out in writing or has some sort of unmeasured working time, for example, sort of senior execs who have autonomous decision-making powers, young workers are also subject to stricter controls. There's also limits on night working of 8 hours in every 24-hour period, again with stricter controls for young workers and those whose job involves some kind of special hazard or heavy physical or mental strain. And daily rest periods, at least 11 consecutive hours in each 24-hour period. Uninterrupted weekly rest periods of at least 24 hours in each 7-day period, or two uninterrupted 24-hour periods in each 14-day period. So there are lots of different areas where working time and rest time need to be distinguished very clearly. Different rules do apply in some sectors, and there are some exceptions, but those are the basic protections.
And I know that the case law in this area focuses on quite a few grey areas when it's not clear whether someone's at work or whether they're resting.
Absolutely right. And there are two issues I wanted to touch on briefly. At first, workers who are on call. So obviously some employers operate a rota system under which workers take it in turns to remain contactable outside of their normal working hours. So IT is one of those areas, for example. Some individuals also live in at work, so for example those who might work in hotels or residential care. Some stay at home but have a work mobile or BlackBerry with them in case they're needed. So is that time working time or rest time?
And what's the answer?
Well, I think if the worker has to remain at the workplace after regular working hours and be available to work if needed, that must be fully counted as working time. The law is very clear on that. Where it's less clear is if the employee is allowed to be elsewhere. So there was a recent case, for example, involving Scottish ambulance workers who could stay off site when they were on call, but they had to remain within 3 miles of the ambulance station so they could respond to emergencies. It was understandable. This meant they had to stay in B&Bs because they lived more than that distance away from their home. And this was deemed to be working time because they did not have the full benefit of rest and relaxation that they would have had at home. Perhaps workers who are able to be at home with friends and family would be treated differently.
So are there any steps being taken to provide us with any more clarity around all of this?
Well, Scott, at European level there are ongoing consultations about how on-call time should be treated. I'm also involved in an Employment Lawyers Association committee which is currently putting together some proposals for reform on working time. Now, the law is not clear at the moment. In my view, a simple definition between active and inactive on-call time would be an effective way to deal with this. So only active on-call time, when you're actually performing work or when you're actually in the workplace, would count as working time. But I think that would be quite a leap for the legislators to take.
I agree, that sounds like a sensible approach. Let's move on to the second issue you mentioned then, Tom.
Well, the second area is travelling time. Now, it's generally accepted, I think everyone who goes to work would generally accept that the daily commute to and from the office is not counted as part of your working time. Travel during the working day, however, for example, to customers or suppliers, would be counted as working time. But how does that apply to home-based workers? If they're not required to go into the office but spend all their time at home or in the field, does the journey from home to the first customer of the day count as working time? Does travelling from the last customer back home count as working time at the end of the day? The European Court is currently considering this very point. And the Advocate General, who, as you know, provides a legal opinion to the court before it hands down its decision, has concluded that yes, it is working time. Travel to and from a customer must count as working time, as during those periods a worker is at the employer's disposal and under their control.
So what does all of this mean for employers?
So if the court agrees, the European Court agrees that travel to and from home for home-based workers or travelling salesmen, that kind of role, must be included as working time, this could have quite important implications, I think, for employers with field-based workforces. So appropriate adjustments to working schedules or perhaps the geographic areas in which travelling workers operate may need to be made to ensure compliance with these minimum requirements. Also worth remembering that employers are required to keep and maintain records in respect of each worker to demonstrate their compliance with the limits on average working time, night work if it's applicable, and the provision of relevant health and safety assessments.
Well, that's about it for this month. Dom is going to resume his normal place in the interviewer's seat next month, discussing the latest HR news and developments with another member of the Taylor Vinters employment team.
Thanks, Scott. It's been really good to chat through these areas with you. Now, if you want to find out more about how we can help you navigate through these potentially choppy waters, my contact details are on our website, taylorvinters.com. So please do get in touch via email. My email address is dominic.holmes@taylorvinters.com. You can find me on LinkedIn. You can also find me on Twitter @domholmes147. Similarly, if you've enjoyed this podcast or you have any suggestions or views to share, please let me know. In the meantime, you can also access all previous editions of this podcast by clicking on the ListenIn icon on our homepage. Thank you for listening in to HR ListenIn.